How does filing bankruptcy affect your significant other? Hi, I'm attorney Leroy Roberson, and that is a question that I get from almost everyone that comes to see me that's married. And even people that are just in relationships ask me that question. So here's the answers. For purposes of credit reporting, filing a bankruptcy in an individual capacity has no effect on your significant other. In a state like California, where I practice, it's a community property state. And even then, if you file bankruptcy individually, that does not show up on your significant other, your spouse's credit report. Don't worry about that. In regards to any effect on assets that you guys may own together, in a Chapter 13 bankruptcy, if that's what you're filing, there's no assets that are even going to get affected, because remember, when you file a Chapter 13 bankruptcy, you're making payments, and therefore you're not really at risk of losing any of your assets, with the small caveat of on tax returns, if you are expecting a refund and you're married filing jointly, you may have to give up that tax refund if it's worth more than $500 in California. So that is the one caveat on if you're married and filing jointly. If you're expecting that big refund, well, you're gonna probably have to give that up. There's ways to minimize what your refunds are gonna be anyway, so we could talk about that later. In a Chapter 7 bankruptcy, if you file that, even though you could be at risk of losing certain things that aren't exempted, if you own an asset with your spouse and you're at risk of losing it, that would be the only way that anything would happen to your significant other in the filing of a bankruptcy, and it's only under that Chapter 7 umbrella because you're unable to exempt the property. But any assets that they own outright that you don't have a claim on, you're not really at any risk to your significant other if you file individually. So as long as they own the property without you on it, then there's not really anything the bankruptcy courts are going to do as far as coming after that asset, especially if they had that asset before you guys got married and it was bought without any, help from you, meaning any of your funds. But, in California, being a community property state makes it a little bit trickier when it comes to property that is owned after marriage. But we can put it together where as long as that asset can be exempted, that's the first protection. But if it can't be exempted, if they own it and you don't, then they're not at any risk of having any issues happen. So that's the quick answer to that question. If you guys have any other questions regarding that, let me know. Give me a call, email, and we can talk about it more. If not, I will see you guys on the next video.